Ladies and gentlemen, a very good morning, good afternoon, and good evening to you from wherever you're tuning in to join us for our webinar today. A very warm welcome to all of you once again. My name is Marilyn Isaacs, and I will be your Master of Ceremonies for today. The Young Members Group of the Asian Institute of Alternate Dispute Resolution is proud to present to you today the YMG's first webinar. Allow me to introduce to you our chairperson, Mr. Charles Ho Wang Mak. Mr. Charles is a PhD candidate in international law and a graduate teaching assistant at the University of Glasgow, a fellow of the Center for Chinese and Comparative Law at the City University of Hong Kong, an honorary fellow of the Asian Institute of International Financial Law at the University of Hong Kong, a research affiliate at SovereignNet at the Fletcher School, Tufts University, and a research associate, at China Law and Development Project at the University of Oxford. He is a fellow of the Chartered Institute of Arbitrators, the Hong Kong Institute of Arbitrators, the Arbitrators and Mediators Institute of New Zealand, the Asian Institute of Alternate Dispute Resolution, and the Royal Asiatic Society of Great Britain and Ireland. He earned accreditation as a tribunal secretary at the Hong Kong International Arbitration Center. A very illustrious career indeed. I will pass the floor now to Mr. Charles. Mr. Charles, all yours.
Thank you very much. And good afternoon, morning, and evening, wherever you are around the world. Thank you to each and every one of you for being here with us today. I'm very pleased to welcome all of you to the first event organized by the AIAGL Young Members Group. So let me introduce our vibrant and international team of Young Members Group. Vishal Agarwal is the vice chairperson, and committee members including Dr. Paula Das, Emily Latafar, Kaijin Lee, Phuket Prakash, Isaac Rosenfield, Kudaja Ng, Jiang Roy, Jenny Fong, Marilyn Isaac, I just listened to her, and Chan Suk Hoi. So the profile of our committee members and me will be available on the official site of the AI-ADL soon. So the young members group consists of members of the Institute who are below the age of 45 in the current calendar year. So the purpose of the young members group is to provide a worldwide network for young practitioners, young professionals and students interested in ADL but have less experience. So in addition, it provides a forum for these young practitioners, young professionals and students for discussions and exchange their ideas and on pressing issues and events in domestic and international arbitration. Also, the Young Members Group provides for various opportunities to young practitioners to develop their careers and network with other young practitioners from all over the world. So last, but definitely not the least, the Young Members Group provides for networking mentorship program, which will only connect young practitioners, experienced leaders in the field of ADL and develop their skills, but also provide experience sharing, knowledge building opportunities to build professional relationship with experienced leader in the field of arbitrations across the globe. So in the future, the Young Members Group will hold networking and other ADL events for the members. Such events may include Young ADL interview series, ADL forums, debate, voting competitions, ADL competitions, essay writing competition, and so on. So stay tuned to our future event. I would like to extend my sincere gratitude to our president, Dr. Professor Sandra Raju, and secretaries of the AI-ADL. Thank you so much for making this happen. So without further ado, let me introduce our keynote speaker of today, Man-Sing Yang, and the Honorary Secretary and the Council Member of the AI-ADL. Mr. Yang, the floor is yours.
Mansingh, yeah. Sorry, Mr. Charles. Mr. Mansingh won't be joining us for today.
Oh, sorry. And let me pass the floor to our moderator, joined by Queen's Counsel.
Thank you, Mr. Charles. Let's move on now to the main part of our event, which is the webinar itself. Our topic for today is entitled The Development of Online Dispute Resolution Under the Impact of the Pandemic. Before we begin, allow me to start off by introducing Mr. Zhenfei, our moderator. Mr. Ng Zhenfei, QC, is specializing in commercial litigation and arbitration and is one of the youngest Queen's Counsel to be appointed in 2018. He has acted as counsel in some 350 cases and as arbitrator in some 30 cases, as presiding, sole, and co-arbitrator. He has appeared before courts and tribunals as counsels in different jurisdictions, including England, Hong Kong, Singapore, Malaysia, British Virgin Islands, Cayman Islands, and Luxembourg. He was recommended by the Legal 500 UK, Legal 500 Asia Pacific, Chambers UK, Chambers Asia as a leading practitioner in many areas. He is a member of several panels of arbitrators. He is described in the legal directories as one of the biggest names for Asia-related arbitration, an absolutely brilliant advocate. He is a very talented silk who has an ability to present practical legal solutions that not only win you battles, but also the war. Very prestigious indeed. Now let me move on to introduce to you our esteemed panelists. First of all, we have Mr. Samir Shah. Mr. Samir is an advocate, arbitrator, and mediator based in Gujarat, India. With more than 26 years of active legal practice and experience, he is the senior partner of Trust Legal Ahmedabad office and founder of SU Shah and Associates, advocates, arbitrator, and legal consultants. Among others, he is also a director of the Chartered Institute of Arbitrators in India, chairman, International Dispute Resolution and Risk Management Institute of the Hong Kong, India branch, and the panel arbitrator, Court of Arbitration for ART, Netherlands. He also conducts litigation before the trial courts at Ahmedabad, district courts in the state of Gujarat, the Gujarat High Court, Debt Recovery Tribunal, and various quasi-judicial authorities. He has personally attended and given advice to all the major clients of the firm, whether from the government sector, corporate sector, or even individuals. During the said tenure, he also completed the articles for solicitor. Next up, we have Dr. Adolf Peter. Dr. Adolf is an associate professor at the Shanghai University of Political Science and Law, focusing on international arbitration, corporate governance, the enforcement of ESG standards in international supply chains, as well as EU law. In addition, Dr. Peter is senior consultant at Beijing Jing law firm, Shanghai office, China, of counsel at MP Attorneys, Vienna, Austria, and international of counsel at Bose Partners, Washington, DC, USA, and Mexico City in Mexico. He holds 2 PhDs and a master's degree in law and religious science, an LLM degree in Southeast European law and European integration, as well as a master's degree in applied business ethics. Furthermore, he is listed as an arbitrator in 10 international arbitration institutions, certified supervisory expert, and was also admitted to the Austrian bar. Dr. Peter is the author of numerous arbitration-related publications. In February 2021, Springer Singapore published his book, CSR and Codes of Business Ethics in the USA, Austria, EU, and China, and their enforcement in international supply chain arbitrations. Last but not least, we have with us Professor Carrie Shang. Professor Carrie is an international arbitration specialist and assistant professor of business law at California State Polytechnic University, Pomona. She has published extensively in the field of international arbitration and online dispute resolution. She is also a special counsel of LTL attorneys in Los Angeles and San Francisco. Carrie has advised clients and been retained as an expert witness in arbitrations around the world. Before joining academia, Carrie was an ADR legal counsel and the acting chief China representative for the Hong Kong International Arbitration Center. She is also a founding member of the California Arbitration and the membership committee chair of the Silicon Valley Arbitration and Mediation Center. I will now pass the floor back to our moderator.
Marilyn, thank you so much for those generous and warm words of welcome and introduction. And thank you very much as well to Charles for introducing all of us to the work of the Young Members Group. We wish you well, and obviously we'll endeavor to support the activities of your group in whatever way we can. Ladies and gentlemen, a very good morning, good afternoon to you all, wherever in the world you may be tuning in. And I am delighted to be your moderator on this Asian Institute of Alternative Dispute Resolution, AIADR, event discussion on online dispute resolution under the impact of pandemic. I am absolutely thrilled to be joined by 3 very distinguished panelists in the course of our panel discussion today, Adolf Peter, Samir Shah, and Carrie Shang. We were due to be joined by a 4th panelist, J. Patrick Santiago, who unfortunately sends his apologies. Due to last-minute developments, he has been unable to be with us for the panel discussion today, although we will very much obviously try and convey some of the thoughts, views, which Jay had previously shared with us during the course of our pre-webinar discussions. We've got a very interesting and exciting lineup of topics for tabling for discussion during the course of this webinar. And it is the most convenient starting point for our discussion really is to trace our steps back to perhaps the onset of the global pandemic, in which online dispute resolution made its fall, And in order to help us step back into the mists of time, so to speak, can I perhaps invite Samir to share with us his views on the historic background to online dispute resolution, or ODR in short?
Thank you, John, for inviting me to go first on this important and interesting topic. Thank you, AIADR, for inviting me on this panel, and the Young Members Group. Thank you, Vishal, for giving me this opportunity to share my thoughts on this topic. Going back to the evolution, I think the ODR actually is related to the evolution or development of internet in the early 1990s across the world. And with that development, when the communication become quite easier and global and faster, and of course it also entailed issues and disputes because of this, and therefore we can look into the historical background of the ODR into three distinct phases. The first phase being the initial development, though if we just because I mean, as experience, we know ODR has been there as part of the international arbitration system as such. We used to, and we still do, teleconference and video conferencing, especially in cross-border disputes, to avoid on cost and time factors. But if we look back, it was not that prevalent initially. People were still using those traditional mode of physical meetings, and as it has been done even now as well. But going back again to the first phase, which started somewhere in early 1990s, there were two main universities in USA which came out with the earlier projects of ODR, the University of Massachusetts and the Maryland. But the most prominent step for the ODR started with eBay, which was the pioneer in e-commerce system of shopping and everything doing on internet. When eBay started the first so-called online dispute resolution system through the process of mediation between the sellers and buyers if they had issues, and it really worked out very well in that period, and that actually led the way for the development and promotion of ODR in much bigger way. And if we just look at the data, which will be helpful for us to understand how successful this eBay model was, that in the year, by the end of year 2010, the data says that they have handled 60 million disputes per year. So this is really very big so far as the ODR model, and we know, and we will be discussing why it would be so successful. But since it was the first, to start with, definitely something new had come up and people were excited about it, and it gave that advantage, and therefore it becomes successful. Though eBay itself didn't run this model, it was initially being outsourced to a platform called Square Trade, but then eBay later on took it over and started on its own. So this is the first initial phase where we can look for the the startup, I mean the evolution of ODR in a bigger way, in the big way. The next, because of this successful model which eBay projected, the next phase came for the new platforms got developed. The startup platforms for ODR got developed, like mediation rooms. I'm sorry. Am I audible?
Yes, you are audible. I think your camera
I
might be
think,
turned
yeah,
off.
there was some issue because I'm traveling out, so there is some issue with the network. Let me just fix it up. Just give me 1 minute.
No problem. I
But
think
anyway,
while
I'll just
Samir-
continue. Yeah, I can just continue. I think that it will be just sorted out.
Yes.
So as I was mentioning about the next phase, where the new platforms came up, like cyber settle mediation rooms, and they came with further innovation in the technology of ODR, which made the process more simpler, more effective. Like where proper negotiation and discussion could take place online for dispute resolution. So this was the second step, where many such platform came up, though not all of them were successful for different reasons. But yes, it led to a revolution in the second phase of ODR promotion globally. And the third phase, which we can see, is because of this further success rate which happened with these platforms and the eBay model, the ODR process was adopted by the government and judiciary of different countries. And this actually gave a much required boost to the promotion and development ODR. The countries like Netherlands, Brazil, UK, Canada, USA, they started developing, the government and judiciary both adopted ODR in the process of dispute resolution. In fact, New York City was probably the first to take up this model for resolution of their personal injury matters, to sort of resolve the backlog on those matters. So likewise, there were other countries and judiciary as well who adopted this ODR as a effective and efficient process of dispute resolution. And therefore, what we have seen now is we have the business entities, the corporates also adopting it in-house as their own in-house platforms. We see some private platforms being developed over a period of time. We see the government and judiciary doing it, and we see also the court annex ODR being run across many jurisdictions. Now, therefore, today, if we see when we look from the pandemic point of view, and that is why I come back to my initial statement where I said that ODR is as such nothing new for the practitioners and the beneficiaries as such. But why we are talking of ODR is because earlier it was an option, but today, after the pandemic and during the pandemic, it becomes a compulsion in order to resolve the disputes, rather than just wait for this pandemic to get over, and we don't know when it's going to get over. So this is now has become a sort of reliable alternative for dispute resolution. And now you see the technology have changed so fast. Today, earlier we were talking about the 2D aspect of it, a simple online, but now we are talking virtual reality. We are talking artificial intelligence. We'll be definitely talking about that later in the session. But this is the scenario right now, that ODR definitely has come a long way. We are now looking at probably ODR being a sort of routine practice mode for dispute resolution, not even domestically, but internationally as well. So I think ODR definitely is going to stay here for a long, long time. Thank you so much.
Thank you very much, Samir. And I think to those of you who have just joined us, just by way of a navigational tool, here on the shared screen is a list, a selection of topics we would like to cover in the course of our panel discussion today on the development of online dispute resolution, or ODR, under the impact of the pandemic. And Samir just gave us a very useful thumbnail sketch of the historic background to ODR. What I'd like to do is just to jazz things up a little, maybe skip over to the third topic, which deals with the comparison of the regional differences in approach between China and the US. So we heard a really scintillating and insightful analysis by Samir about the historic origins of ODR, about how it's always been here with us. and perhaps the only difference between what we experienced by way of ODR before and what we're experiencing now is a function of scale. In other words, as a result of global events, we have now begun to use ODR on a far more extensive scale than we perhaps had previously done. And Samir made the point that ODR is here to stay, perhaps due to the familiarity with which we have adapted to the use of online dispute resolution. But the question, though, is the preference or the experience with ODR uniform across different parts of the world? And we are absolutely thrilled to have Carrie Shang here join us here for our panel discussion this afternoon, because Carrie uniquely has experience not just of practice in mainland China, but also the United States. And Carrie, perhaps you could enlighten us with a comparison of the regional differences in approach to ODR between China and the US.
Sure. Thanks very much, Jinghui, for the question. Also, thanks for the great moderating and also for everyone's wonderful discussion so far. So I think a good thing to answer to just to echo your comments a couple minutes ago is that I think in different regions of the world, people are embracing the development of ODR, even though there are a lot of different variations in the stages of development and also kind of ways that ODR is taking direction to. So I think there are a couple of significant differences between the ways that ODR has been developing in the United States and in China during the pandemic, even though in both regions, ODR has been developing very, very fast. And the first primary difference is really rooted in the difference in the political system, in the state functionality. So institutional supports are vastly different from the United States and China. That's my first comment. By that, I mean that in China, we do see a lot of ODR developments that are hugely supported and funded by the state government, the central government. Even I'm not sure if Samir has differentiated between court annexed ODR or kind of public function ODR, private ODR in his brief background introduction. But in my kind of brief answer, I think I'm going to mingle the two things together so that I'm not going to differentiate public funded ODR versus private sided ODR. But in China, you can see that most of the ODR developments are actually associated with the development of a smart court or actually the court reform project. Even though there's some development, like some new development in online mediation, many of them are actually developed in a way that they are connected with the court in a centralized or kind of one-stop shop platform. And we know that there are different internet courts that develop in different regions of China. There's Hangzhou Court, Beijing Court, Guangzhou Court. There are a couple of national guidelines that are encouraging the development of ODR and also the following online, especially, I'm not sure, I think probably some of you know that Supreme People's Court actually promulgated a notice in early 2020, which the COVID was just about to show the world its force, that there was an encouragement of online litigation. It was totally encouraged and actually ordered, mandated by the Supreme Court of China. So that's basically, you can see a lot of different developments of ODR in China, but I think most of them are associated with some of the court reform projects. In the United States, development ODR is wholly a market-driven behavior. And therefore, we have a lot of ODR providers, but many of them are smaller ODR providers, and normally they have to provide their services to some of the bigger arbitration firms. Like we know JAMS has developed a e-dispute resolution panel, ODR forum with another private company. Samir mentioned eBay, and we probably know Colin Wu, who's the founding father of eBay's ODR project. He has founded his own ODR company. It's called Moderia, and they're also kind of promoting their new platform in different ways throughout the pandemic. But the thing is that for private ODR provider, the thing is that they have to sort of prioritize the financial viability in a particular ODR project, because we know the initial ODR was really developed with smaller claims and consumer claims. ODR, many of the ODR providers do not have competitive edges that bigger arbitration centers have. So that's basically, the thing hasn't really changed very much, even though people's perception of ODR has kind of changed. The financial viability of ODR platform hasn't changed very much, at least in the United States. I'm going to say that there are a lot of different ODR providers, all private startup companies, but the competition is really severe there. That's different from China. There are some public court-annexed ODR development in the United States. We see different state courts, Michigan, Ohio, New Mexico, some regions of California have developed smaller scale ODR project, encouraging online filing. I actually have a map here. I think I can share my screen, so I want to do that. So,
Yes,
so this is basically where you can find the internet court or ODR equipped state court in the United States. You can see that there are many of them, but for a vast country like United States with such a high caseload, it's just not enough of them. So but this map is only updated until 2019. So we see some kind of new courts being established in different parts of the United States. However, basically, because of the political structure of the United States, all this kind of developments are very, very slow comparing to a centralized planning country like China. So I'm going to pause my share. So, but that's the first, I think the biggest difference between the two countries. And then some of the smaller differences I observed, I think in China, the ODR development focused a lot more on hard technologies, like they have been promoting the ways that your court can do video recognition, AI judge, voice recognition, evidence stored on blockchain. So many of the development are hugely focused on hard technology. However, in the United States, I think a lot more considerations have been given to more kind of soft aspects of ODR, such as accessibility issues, like digital equality, whether disabled groups, elderly, and younger people can actually have access to those ODR platforms. So they kind of more approach the ODR development from a way of access to justice perspective, which is also a little bit different from China's perspective. And also, apparently in the United States, a lot more focus have been given to privacy protections of litigants, of disposition participants, of parties, of anyone involved, stakeholders, which I'm pretty sure that China has been improving this part in recent years, but this is not a huge focus in China, at least in the initial development. I mean, there are a lot of debates of what kind of level of privacy should be given, protected to people as those courts are moving online. I'm not sure if I'm taking too much of time here in answering this question, but basically I think that's some of my observations as far as for different routes of the ODR development in the two countries.
Carrie, I found that extremely insightful. Thank you, because not only did you analyze, obviously, the differences in approach, in other words, a public-led approach in China, as opposed to a market-driven approach in the United States, but you very helpfully also explained what are the differences in focus insofar as China and the US is concerned. If I couldn't help but be intrigued, and if you wouldn't mind just sharing that map again.
Sure, I can.
That's all right.
This map is actually interactive. I think it's developed by the American Bar Association. I'm sure they're updating it. I'm hoping that they're updating it. So I'm just sharing the link here, so everyone can actually be checking with it, or maybe helping updating with it if you have time in the future. But yeah, here's the link.
Terrific, terrific. This is wonderful. One of the things I couldn't help but notice was when you shared that map and we were looking at it, I couldn't help but realize, albeit this map was only current as of 2019, right. Is that the great majority of the pins on your map was in fact in, I think you see that there's this state right at the top, which I think is Michigan, if I recognize the map correctly.
Yeah, this is Michigan. Yeah, this
yes, there we go.
Of internet courts are actually in Michigan, because they do have a state initiative encouraging developing of ODR annexed courts.
Yes, the reason why I found that interesting was because you would have perhaps not necessarily assumed that the state with the highest density of court annexed ODR would be Michigan, as opposed to, say, New York or California. But it is nevertheless fascinating that that was the position as of December 2019, of course, which is the date of this map. And what is remarkable is that what they had spearheaded in Michigan, which is a public-driven initiative, court annexed ODR, is of course prevalent in China. And it was also very impressive to note that the initiative driven by the Supreme People's Court itself came into fruition as early as early 2020, of course, when we were all beginning to experience changes in our work arrangements as a result of the global health situation. So that is extremely insightful. Thank you so very much, Carrie. So what we have done, ladies and gentlemen, we've taken a little tour in our discussion on the development of ODR under the impact of the pandemic. We first started with tracing the historic origins of ODR in a discussion with Samir, where we looked at how ODR has evolved over the course of time, and Carrie then masterfully took us through a comparison of how ODR has developed its different focuses as between China and the United States. What I'd like to do now is to change the focus of our discussion very, very slightly to a different topic. And I'm just going to share our little agenda list again. So this is topic item number 4, which is due process considerations re ODR. So we've heard now about how ODR has always been with us, but it's now used on a far more extensive scale, perhaps driven by necessity, and maybe even by changed preferences, because of course, the more familiar we have all become with ODR, the more likely it is we are prepared to accept the use of ODR, even when it doesn't become, strictly speaking, necessary to resort to online dispute resolution. You'll see that there's been a lot of investment, certainly in China at least, on court-annexed ODR, which perhaps is emblematic of the fact that ODR is here to stay for the foreseeable future, if not for the long-term future, which is also a message which Samir had touched upon in our earlier discussion with him. That nevertheless gives rise to a separate question altogether. Are there due process considerations with the use of ODR? In other words, are there concerns that ODR might lead to due process complaints in circumstances where there is, it might be said, an expectation for dispute resolution that is conducted in person, face-to-face? Is there such an expectation? And if there is, does it and should it lead to due process considerations? For that, I'd like to invite Adolf to join us and to share his views on whether or not ODR gives rise to due process considerations and how the international dispute resolution community has reacted to this particular topic.
Thank you very much, Chern Fei. I also want to express my gratitude in particular to AIADR and Professor Sundra Raju for inviting me. I think this is a still very important topic. I mean, I'm based here in Shanghai, so it is still here quite challenging as far as travel restrictions is concerned. And if we have here an arbitration, we have here a lot of very good, excellent arbitration institutions. Just to mention a few, the CTAC, of course, in Beijing. We have here in Shanghai, the Shanghai International Arbitration Center. We have the Shanghai Arbitration Commission. We have in Shenzhen, of course, the SCIA. So we have here excellent arbitration institutions. But right now, due to the travel restrictions still pending here in China, we still face issues, and online dispute resolution is of utmost significance. But I do not want to talk today about Chinese arbitration law or how we conduct here in Shanghai online arbitration. Actually, I'd like to talk today about Austrian case law. So you might think, okay, Austria is quite a small country, has a population of around 9 million people. But it's very, very important, actually, in arbitration. The Supreme Court of Austria has a very, very good reputation, very efficient, very effective. Austria is, of course, a neutral country. It hosts several international arbitral institutions, such as the ICC, of course, the Vienna International Arbitral Center. So we have a lot of arbitrations where the applicable arbitration law is Austrian law. And we have, of course, going back to China, CITAC. CITAC established an office in 2018 in Austria. So it's called the CITAC European Arbitration Center. And it is planned to administer CITAC arbitrations in Vienna. This is very, very important when we think about the Belt and Road Initiative. So we're expecting here, of course, still expecting here a lot of disputes between Eastern European companies and Chinese entities. So construction-related disputes and so on. So this is really crucial because in such an arbitration, of course, the seat of arbitration would be Vienna, Austria, and that means we have the applicable lex arbitri Austrian arbitration law. Yeah. So having said that, I want to now come to the case law. In July 2020, so it was really right at the point where the pandemic started, we already had a decision from the Austrian Supreme Court. So that's how efficient our Supreme Court is, and it is always Austrian Supreme Court is really arbitration friendly. And you will see that when I talk about now this case law. So July 2020, already final decision. The Austrian Supreme Court examined whether conducting a hearing in an arbitral proceeding online by means of video conference violates the principle of due process. If one party objects to these online proceedings. The respective arbitral proceedings, they were seated in Vienna, Austria. That's why the applicable lex arbitri was the Austrian arbitration law. And the arbitration was administered by the Vienna International Arbitral Center. Also an arbitration institution with a very good, with an excellent reputation. So the arbitral tribunal in this case was challenged. All three arbitrators, it was an arbitral tribunal composed of three arbitrators. They were challenged by the US respondents. So we had respondents coming from the United States. So first, with such a challenge, it's actually the competence of the institution, of the arbitration institution itself, VIAC, rejected this challenge. So as a consequence of this rejection, the challenge had to be decided by the Austrian Supreme Court. I will talk about this procedure in a moment. During the pending arbitration, as a matter of fact, in the case management conference, so at a very, very early stage, actually, the American respondents, they rejected the proposed remote hearing. They suggested, still in this challenging time, and back then in Austria, we also had a lockdown, of course, and it was impossible to conduct in-person hearings. So it was not possible. Still, the American respondents, they rejected to an online arbitration, or online hearing, I should say. The respondent argued for the hearing taking place at a later point in time, in person. But back then, we didn't know very much about this COVID, how this will develop, what variants would come, how dangerous it would be. So this basically would have meant maybe it's postponing it indefinitely. So the tribunal decided that the hearing would be conducted by video conference. Starting time is also important in this case because this was one of the issues brought up by the respondents. Starting time was 3 p.m. Vienna time. The respondents were based in Los Angeles, California, so it's a 9 hours difference. It was in LA, it was 6 a.m. in the morning. At the start of the hearing, then the hearing actually took place online, and already at the start of the hearing, the respondents again complained about the hearing taking place remotely online. So they really complained about this virtual hearing method. After the hearing, the respondent, they promised to come back now to this challenge proceedings, because it's also quite important to know about that. After the hearing, the respondents challenged all 3 arbitrators. So including the arbitrator, the co-arbitrator that they actually nominated. Also doesn't happen all the time, to be honest. So first, challenge, as I mentioned before, it had to be decided by the arbitration institution, by the Vienna International Arbitral Center itself. But pursuant to section 589, paragraph 3 of the Austrian Code of Civil Procedure. So why Code of Civil Procedure? Because the Austrian arbitration law is embedded in the Austrian Code of Civil Procedure. So this section 589, paragraph 3 stipulates that if a challenge against arbitrators is not successful, in this case it was not successful because the VIAC rejected the challenge. The challenging party, which means in the case at hand it's the American respondents, may request within 4 weeks after having received notice of the decision, of the VIAC decision, rejecting the challenge, the Supreme Court to decide on the challenge. So the Austrian Supreme Court decides on this challenge. And this decision, the Supreme Court's decision, is final, and it may not be appealed. And more importantly even, if this later on in potential setting aside proceedings, this argument cannot be brought up again. Though of course the setting aside proceedings, because we have the applicable law, Austrian lex arbitri, so setting aside proceedings again would have to be taking place in Austria, and the competent court is the same court, it's the Austrian Supreme Court. And I just want to add also something. For example, if guerrilla tactics and these kind of things, and maybe some strategy, if the respondents think, okay, let's not do it right now in the pending arbitration, let's do it later on in a setting aside proceeding, it's not working. because then it would be too late. Would be too late because it could have been already brought forward, and it must be brought forward in the arbitration. So this is, and most importantly, this provision, the access to the Supreme Court of Austria, is mandatory. It's mandatory lex arbitri. There is no way that the parties could now say, come to an agreement, the arbitration agreement, okay, we do not want to apply this rule. No, this is not working, it's mandatory. So if we have arbitration institution rules providing a different procedure, it does not matter because this is mandatory lex arbitri. Lex arbitri is the law of the arbitration. Yeah. So this is the way it goes. That's why this case was brought forward to the Supreme Court, and the Supreme Court decided on that case. Yeah. Among other things, the respondents argued as follows. They brought forward a violation of the principle of fairness, of the right to be heard. They brought forward unequal treatment because of the different time zones. And they mentioned that the tribunal did not provide the necessary measures to prevent witness tampering. Witness tampering. For example, there may be other persons present with the witness during the witness examination, or witnesses may receive chat messages. So they really brought that forward, may receive chat messages while being examined. The Supreme Court decided that conducting hearings remotely does not violate the principles of being treated fairly and the right to be heard. This was so important back then because, to my knowledge, this was the first time a Supreme Court worldwide decided on that issue. Because, I mean, you can see it's July 2020 was the first time. So you could say that the Austrian Supreme Court was at that time a trendsetter. So the Supreme Court explicitly confirmed that remote hearings would be permissible even if one party objects. Supreme Court mainly based his view on Article 6 of the European Convention on Human Rights. So why is that? You have to understand that in Austria, the European Convention on Human Rights is on the level of constitutional law. So it can be directly referred to or relied on. Article 6 of the European Convention on Human Rights addresses a party's right to effective access to justice and the right to present the case. The Supreme Court recognized that insisting on an in-person hearing could lead to a standstill of the proceedings. I mean, it's also, I teach arbitration in my university, and I always tell my students as well, this could be used as guerrilla tactics. Just imagine if the respondent has a very, very bad case, abuse of process, denial of justice. So just prolonging everything. And now is in particular now in the case of China, nobody knows exactly how these travel restrictions now will develop. And I think it is now very, very challenging still for all the parties, if they're not residing in China, to actually travel here to participate in person in such proceedings. And I mean, also the witnesses, that there's some experts, so many, the parties, yeah, so many people would have to travel to the hearing. So this, in particular, now with China is quite still an issue. So abuse of process, denial of justice. That's why it's so important to have these arbitrations or these hearings online. And by the way, speaking of China again, all the major arbitration institutions, they're perfectly ready to conduct arbitrations online in a very, very professional way. But coming back to Austria now and to the case. Regarding the difference in time zones between Vienna and Los Angeles, 9 hours, the Supreme Court held that it was impossible to hold online hearing, to hold an online hearing during the core business hours for all hearing participants. But the situation, this time difference, this was impliedly accepted by the US respondents, impliedly accepted by the US respondents by accepting the arbitration agreement administered by the Austrian arbitration institution, the Vienna International Arbitral Center. So that cannot be a surprise, and that's why the Supreme Court of Austria actually refused this argument from the respondent. And in relation to witness tampering, the Supreme Court noted that the risk of witness tampering also existed in in-person hearings, for example, by means of witness coaching. And I think, Carrie, you know that very well. There's a major difference as far as witness coaching is concerned in the US. That's totally normal in the United States. But here in Austria, for example, it's not normal at all. We have a code of professional conduct. And we need to be, as an Austrian lawyer, very, very careful as far as witness coaching is concerned. It's basically not allowed. We are not allowed to influence the witnesses. So we have to be very careful with that. We'll publish actually an article on this topic very soon in the arbitration journal of the Chartered Institute of Arbitrators, the next edition. So furthermore, the Supreme Court, I should say, there was also an example, for example, that the Supreme Court mentioned, okay, in in-person proceedings, such witness tampering could as well happen by means of witness coaching prior to the hearing. So, and furthermore, the Supreme Court referred to the technical ability of all participants to observe the person to be examined closely, from the front. The possibility to record all the evidence and the witness examination, the option to instruct the witness to look directly into the camera, and keeping his or her hands visible on screen at all times. And this would make it impossible to receive any chat messages or to write anything. Or another argument that the Supreme Court made was showing the room in which the witness testifies. And that would ensure that no other person would be present. So this was a very, very clear and important trend-setting decision. And I would also suggest, for all arbitrators, consider such issue already in procedural order number 1. All these evidentiary issues. It's not only online hearings. You need to also consider whether you allow cross-examinations and all these kind of things. Do it already in procedural order number 1. This way, nobody can say they are surprised. And this is so deal with it in procedural order number 1. Thank you.
Thank you very much, Adolf. In fact, if I can just by way of a supplement, say that the risks or dangers of witness tampering in the course of ODR, online dispute resolution, is sometimes exaggerated, because I don't know if those of you who are listening in, who are watching this, to the extent that you have any experience of cross-examining, or I hope not being cross-examined virtually, you might have realized that it's quite difficult actually to be cross-examined and looking at your phone, or perhaps receiving instructions, verbal or otherwise, from someone else who is in the room without actually being noticed. Well, for starters, you are obviously going to be observed in perhaps greater detail, and dare I say it, higher resolution, image-wise, than you would do if you were there in person. Most of these virtual hearing platforms will enable the speaker to be zoomed in. Your image will be blown up on the screen for everyone to see, such that anything down to a facial tick, non-verbal reactions, etc. You also have your eyeballs start darting all over the place because you are receiving instructions from someone else in the room. These things are visible. So it sounds to me, Adolf, that the Austrian Supreme Court not just got the right result, but they got there ahead of many other similar appellate courts across the world. But that being said, though, Adolf, some of the issues that were raised and ventilated by the US respondents in that case do raise genuine and legitimate concerns about ethics in terms of online dispute resolution. And I think that's a very useful jumping off point for us to segue to our next topic, which, ladies and gentlemen, you'll see on the shared screen, which is topic number 5. It's about ICODR and ethics in ODR. And for that, I'm going to turn to Carrie. You've heard, obviously, what Adolf had to say, and his, expert analysis, masterful analysis of the competing submissions of the parties in that case that came before the Austrian Supreme Court. And you may have heard me make the observation that some of the concerns which are expressed by the US respondents in that case are obviously genuine concerns, real concerns, credible concerns about the trials and tribulations or the risks that you might encounter when you're conducting online dispute resolution. This gives rise to ethics questions. I'm very interested to hear your views about the prevalence of ethics-related issues in ODR. Over to you, Carrie.
Thanks, Jinbei. And I'm not familiar with the case Adolf just mentioned, so I really learned a lot from Adolf's introduction of that case, very clear analysis of that case as well. Concerning ethics, I think that's a huge topic in online dispute resolution, and it's something that concerning basically every ODR stakeholder, including those that are involving in ODR system design, practitioner, and parties. So there's international organizations. I think it started in the United States, but basically it is very well attended and very well joined by international online dispute resolution experts, and it's called the International Council for Online Dispute Resolution. I'm going to share my screen again just to make it more or easier for everyone who's interested in this particular topic. So so this is an international organization, and they have just adopted a ODR ethics standards, actually very, very recently updated, May 3rd, 2022, based on experiences and expertise of ODR practitioners all over the world during the pandemic, basically based on what they learned, which worked, which didn't work, which could have worked better during the pandemic. I really like the case mentioned by Adolf, and actually, as someone who has some experiences not only in arbitration but also in mediation, Personally, we understand, as Junfei mentioned, the difficulties of witnesses being examined during online in any type of cross-examination proceeding, but also in mediation. A lot of mediators express their concerns of very difficult to be relating to any party in complex mediation, particular mediation involving emotional issues such as family mediation or other type of mediation that requires some type of psychological analysis or support rather than totally law-based or rule-based answers. So it's really something not only concerned with arbitration, arbitrator, but also mediation, mediators. So I think concerning ethics ODR, this is a very easy and adaptable standard, and ICODR has been promoting this standard. They have been doing a lot of roadshows and talks all over the world to make sure that people kind of understand, and maybe more and more practitioners are going to adopt this standard during their practice. So, so everyone who's interested in standard can rate themselves, but I would just like to emphasize 3 points that I think really worth emphasizing out of, not sure how many points, but out of all the points that they're considered important by the ICODR. First of all, I think it's really important to emphasize the accessibility issue of ODR. I think I kind of alluded to this topic during my introduction of differences between emphasis of American and Chinese development route, because I think every practitioner has to bear in mind that even though ODR has its convenience, has its cost effectiveness, it's really not for everyone, especially some people that are here having some, for example, hearing or they're kind of hearing abilities are impaired by certain ways, or elderly who cannot read very well on computer screens. So any type of ODR, when we're designing the system or any type of ODR standard being adopted, people has to bear in mind that ODR is something that must be easy for parties to find within a system, and it has to be basically easy for anyone who agreed to this process to participate in this system. So it has to be accessible and fair system. And also equality, it is an issue that we haven't really talked about in this panel, but it's something that is also very important to emphasize. It has been emphasized by the ICODR. So ODR providers must treat all participants with respect and dignity. And it also has to strive to ensure that no process or technology incorporated into ODR provides any party with a technological or information advantage due to its use or non-use of ADR. And also bias is an issue that, well, a lot of us are familiar with the algorithm process, which can generate a lot of different kind of biases in any type of automatic decision-making system. We know that ODR is kind of moving towards a more automatic decision-making system. A lot of places are starting to trial or experiment on or AR decision-making system, the AR AI decision-making system in one way or another. But when those type of systems or development used, we have to really be aware of that. Biases are everywhere in algorithm system design. So it's something that's also we have to bear in mind when we are using or when we are adopting a certain ODR standard. Fair and impartial. I think this also goes back to my own point, my earlier point. ODR process must treat all parties equally and with due process, without bias, the benefits for or against any individuals, groups, entities, and also conflict of interest must be disclosed in advancement of any commencement of ODR services. Even though we're moving online, we're not really giving up any type of entitlement of right, and we are making sure that ODR judges, arbitrators that you choose, mediators you choose that are going to be adjudicating or mediating online are disclosing ask enough information as if they are adjudicating or mediating in the offline process. So I really think that this standard is very well developed. There are a lot of points that are emphasized by the experienced ODR providers and practitioners that haven't been really emphasized very much in some of the other conversations. So I really encourage who's interested in ethics ODR to maybe have a better or more detailed read of the standard and see how that fits into your own practice or understanding of the ODR process.
Thank you very much, Carrie. I have to say that prior to our webinar and prior to our discussions in anticipation of today's webinar, I hadn't even appreciated there was an International Council for Online Dispute Resolution, ICODR. So there you go, ladies and gentlemen, to those of you who have attended a number of discussions about online dispute resolution, I hope that you have found this particular webinar insightful and informative in terms of the focus that we have placed on topics which you may not necessarily have encountered in other discussions on online dispute resolution, including, of course, the existence of an International Council for Online Dispute Resolution. So I thoroughly recommend those of you who are interested in the topic to check out the ICODR's website. And of course, there are also guidelines which are published by some of the leading arbitral institutions as well in respect to how virtual hearings or online dispute resolution is to be conducted. Thank you very much, Carrie, for that. And that was a very useful bridge between the discussion that we had with Adolf in terms of due process considerations, which then nicely fed into Carrie's exposition on ethics in ODR. If I can just trouble you, Carrie, just to unshare your screen so that I can just show our friends in the audience what we are going to be discussing next. And whilst Carrie is in the process of doing that, can I just again reiterate to everyone to populate any questions you have in the chat box function. There is a Q&A segment which we will come on to at the end of this panel discussion, where we will pose your questions to the panelists. So keep them coming. We will use the chat box as a repository for these questions, which we will come on to at the conclusion of our panel discussion. Now, we have been talking about historic background to ODR. We talked about the comparison of regional differences in approach between China and the US. We looked at due process considerations, and then that fed into an interesting exposition on the topic of ethics in ODR and introduced, at least to me, to the existence of the ICODR. I want to come on to next, and this is topic 6 on the shared screen, to something which Samir had touched on earlier on when we talked about the historic background to ODR. And you may recall that Samir had talked about virtual reality. And that is an allusion to what we're going to covering next, which is the metaverse. And as perhaps an illustration of the dynamism and the ability of dispute resolution practitioners, dispute resolution service providers, and institutions to innovate, the ODR, the concept of ODR itself has evolved from perhaps what you might regard as a flat screen 2D virtual hearing platform to obviously all sorts of support networks, softwares, applications, for instance, online disputes, online documentary management systems, amongst other things. You have obviously e-bundles these days, but interestingly, as of late, we have seen an increased interest in arbitration in the metaverse. Now, you might be asking, what's that? And this sounds interesting. Is this the new frontier, as it were, of online dispute resolution and dispute resolution generally? Samir, would be very interested to hear your thoughts on this interesting new frontier. Is this a new frontier or a false dawn metaverse?
Well, yes, it's definitely a very interesting technological development, I would say. And honestly, I am also getting further knowledge about it. I had a first-hand understanding because I was discussing this with one young developer in India who has also developed this platform, and how that can be used for arbitration and mediation, for that matter. And in fact, ICC launched this technology showcase in the recent Paris Arbitration Week, and which made the practitioners and the people associated with ADR about this concept of metaverse. So basically, it's a kind of, it's obviously a virtual reality where you see yourself in a bot formation or in a clone kind of a feeling, sitting there as if you yourself is sitting in that room, as we normally conduct arbitration in-person way, which gives you that feeling of not looking at the screen as a flat screen, as you just mentioned, and which of course has its own issues, especially in mediation, because when we talk of mediation, unlike arbitration, it is more related to emotions, and therefore it becomes more important to have that human touch to the whole process. And therefore, to an extent, in my personal view, ODR is not that effective so far as mediation is concerned. And therefore, I think to that extent, to overcome that issue of that human touch, of that closeness, that which we feel when we are in person, I think metaverse may, I'm not sure as of now because it's too early to comment on it, but metaverse may be able to resolve that issue of the feeling about not looking at the flat screen, but as if it is being conducted in person. Now, how far it's going to workable, obviously there would be definitely many issues, including of the process abuse, the ethics involved, and so many things. So it is still in a developing stage, but I think to an extent it can work to be a good model to cut on the cost and the time factor to a larger extent, especially in cross-border disputes, to be effectively resolving disputes, especially, as I said, in mediation. May not be in arbitration, because arbitration can definitely work well even on an online platform that way, simple online as we are doing it right now. But for mediation, yes, this could be a game changer. That's all. Those are my thoughts. Thank you.
Thank you very much. Samir, it is incredibly insightful, and I just want to give a shout out to a practitioner from Allen and Overy, Hong Kong, called Elizabeth Chan.
Yeah.
CHAN,
Yeah.
who has been a pioneer, really a leader on metaverse, yes, in online dispute resolution. Fabulous. Well, the discussion has focused obviously on not just the history, but also the future. And we've just been talking about the metaverse. Now, however, one common denominator of all of our discussion to date has been what pre-existing dispute resolution practitioners are doing. In other words, those of us on the panel and those of you, ladies and gentlemen, perhaps most of you in the audience, pre-existing dispute resolution practitioners, arbitrators, counsel. What are we doing in this online dispute resolution field? How are we adapting? How are we evolving in this regard? And what are the trends for the future? But what I'd like to do now is, again, shift the plane of discussion to a slightly different topic, which is, and you'll see this on the shared screen, It's on the efforts by universities and institutions in equipping the next generation of ADR practitioners in grappling with ODR and other new technologies. Because we've been talking about what we, as the current generation of dispute resolution practitioners, are doing. It will be interesting to hear from our panelists what their views on how universities and institutions are helping the next generation, the future generation of practitioners in grappling with ODR and other new technologies. And for this, I'd like to turn to Adolf. Perhaps you could illuminate us, and of course, you are in the unique position of not just having experience on this from an Austrian perspective, but also a Chinese perspective by dint of your work in Shanghai.
Yes, I am an associate professor in the Shanghai University of Political Science and Law, and I am actually teaching very intensive arbitration classes. Among those arbitration classes is actually the preparation class for the Wismut competition. So again, we come to Vienna because as many of you probably know, the Wismut, the arbitration Wismut, is actually the most important competition in terms of arbitration. It's a mock arbitration, and hundreds of universities worldwide participate in this Wismut, and there's also numerous pre-moots preparing for this Wismut. The Wismut usually starts in the fall, around September. The case is published, and yeah, it takes more than half a year actually. The final oral hearings, they are actually in April, yeah, every year, and the students, they have to prepare their written submissions, so they have to be claimant and they have to be respondent. So they have to, this is really excellent because they have to really analyze the case from both parties' perspectives. That is really very important. And having said that, the last couple of years, of course, also the Wismut organizers, they had to adapt to this COVID-19 situation. Usually students, arbitrators, arbitration practitioners, they would meet in Vienna and have a very nice week together and a lot of networking. And yeah, it's really was always looking forward to it, but now it's online. So we had to adapt here. And also my students. So I have here classes very intensive. I mean, these classes are very intensive. It's blocked. I usually do it on a Saturday. So it's a nice weekend activity, like 6 to 8 hours, blocked seminars, regular practice session about all kinds of arbitration from the beginning until the end, and of course the assessment of the case and preparing for the written submissions, and also preparing for the oral hearings. And speaking of oral hearings, of course, we need to prepare for virtual hearings because Wismut is now taking place also virtually. So in this context, I've been teaching a lot also very important guidelines. We have not had the chance to discuss those guidelines today. There is a couple of guidelines out there. For example, the ICC guidelines, note on possible measures, and possible measures aimed at mitigating the effects of the COVID-19 pandemic. It's a very long title. Yeah, and these, I don't want to bore you now with the contents because it's very detailed, but one thing I want to mention here, Annex 1 includes a checklist suggesting a 360-degree camera view for all participating rooms. So it's a brilliant idea. Other guidelines, for example, the guidance note on remote dispute resolution proceedings by the Chartered Institute of Arbitrators. That's another example. Among other things, they talk about semi-remote hearings. This is also something we have not discussed yet. It's also a possibility, of course. Just think about an arbitration in Vienna. CETA arbitration seated in Vienna. Let's have this example. Maybe a European party against a Chinese party, and with China now the travel restrictions, maybe in Austria we can have this hearing. But maybe the Chinese party only can actually join online. So semi-remote hearings is another thing. But it says actually in these guidelines, in the interests of equality, it is preferable that if one party must appear to the tribunal remotely, both parties actually should do so out of fairness. So this could potentially be a reason of a challenge, but I'm not actually aware of such a challenge. So, but maybe somebody has experience with that. Then there's also other guidelines, for example, the Seoul Protocol. Seoul Protocol on video conferencing in international arbitration. So I'm not going to go to any details here. I just want to say there's actually a lot of guidelines out there. There's a lot to teach. We actually also we offer a pre-moot in our university. The Shanghai pre-moot is organized by the Shanghai University of Political Science and Law. We have every year increasing number of universities taking part, and of course it was also held online. So our students, we have a lot of online experience. Speaking of online exams, lectures, now everything basically had to take place online. And also exams, and I have to say exams, it works very well. So like what you mentioned, Chernfei, I mean, it's very difficult and challenging for somebody that really wants to cheat. I mean, you clearly can see that, and I mean the camera, it's on the eyes, and maybe it's even more challenging when you have an oral exam via video conferencing. I think that works quite well. It's better than have a written exam where potential cheating it's much more easier. But anyway, this all works very well. And I have really good experience with that, and I really must say that my students, they're used to that, and I think because of this experience and also the Wismut, this online lectures, this online exams, I think that the next generation that we're teaching right now, for them, it will be completely normal. They will be used to virtual methods, to virtual hearings. So I do not see any problem for that. But I think, and we see that already, speaking for Europe now, and I've been discussing this with a lot of colleagues. It's now possible again. It's now possible again to have in-person hearings, and I see a clear preference. I do not know about your experience, but I see a clear preference to the return of in-person hearings. But please let me know what's your experience with that. Thank you.
Thank you very much, Adolf. In fact, to the point about where you have the prospect of semi-online hearings or semi-virtual hearings where only one party is represented. I recall that there is an authority in the Hong Kong Court of First Instance. I forget now what the name of that authority is, but the presiding judge there was Mr. Justice Coleman. And there was an argument, this was, I think, at the start of the pandemic in Hong Kong, whereby there was a prospect of a telephone hearing and whether or not it was possible for one party to be in court during the course of this telephone hearing, whereas counsel for the other party was not. And it was held that it would be preferable for, if both parties couldn't be in court in person, for any such telephone hearing to be conducted in circumstances where both counsel were not in court. In other words, they were accessing the hearing, participating through the same means. And I had previously encountered similar arguments in arbitrations in which I have been involved. So very interesting to hear your take on it. Samir, I'd like to know from your perspective, because obviously you've got quite a lot of experience on this topic as well. If perhaps you could shed some light on, in your experience, the sort of steps which institutions and universities are taking to equip the next generation of dispute resolution practitioners to deal with ODR.
I echo what Adolf mentioned about, but more than that, what I have experienced is that today's generation, the young generation, is very well versed with the technology, and they are very fast to adapt to the new improvement in the technology. So as such, we don't have to teach them. They have that kind of knowledge, understanding of how the technologies are working. And especially the platform like Zoom has really, changed the overall system of communication and relationship, basically, I would say, whether we talk from a professional angle or even from personal angle. And this is what, today we are conducting this webinar, is a perfect example of, bringing the world together. It has become now a global digital world in which we are living, and we have to accept this. Now, coming to the university, I just want to give an example, as Adolf was mentioning about the pre-moot. This year in February, I conducted, I think, one of the biggest pre-moot to the Wismoot, which is known as which called the Asia Pacific pre-moot to the Wismoot, and we had 300 teams registered from across the globe, and everything was conducted on Zoom. And the theme which I took for this pre-moot specifically was inclusivity. So it is a step ahead of diversity, because we have been talking a lot about diversity, but I went a step ahead and talk about inclusivity. So what I did, the website which I had developed, and mind you, this is all through the students. There was not a single professional involved. I had a team of 50 students as a backend support working on this. So they only had developed this website, which was accessible to anyone who's maybe a blind person, who's visually impaired, who's hearing impaired. That kind of a website we had developed. Yeah. And it also had option for Braille printouts as well. And then during the whole event, I had a speech therapist, a sign language expert on hold for anyone requiring that, in case of some person who's there as a team member, who has that kind of impairment, then I had a sign language interpreter put on hold. And I actually showcased this in the inaugural and the closing ceremony, how we can use that, even on a digital platform. And it was a very, very successful event, and it definitely has laid a big standard for us, and we'll be doing this every year. So this is what, and so the idea is that, and as I said, it was all student driven, We were just 5 people who were guiding them from different region, but we have never met in person. Everything happened on Zoom. So I was in India. There was an accommodation from Melbourne, another one from Hong Kong. So, likewise, we got everything on Zoom or emails. So this is one example of, how the new generation has quickly adapted to this technological development. The second aspect is, even when I have been conducting arbitration, when I'm sitting as a sole arbitrator, in one such matter, it happened that the respondent had a network issue. Now, this is a drawback actually of ODR. And it happened actually with, in my earlier presentation as well, the screen just went blank. So that's the drawback, but we need to get used to it. So what happened that this respondent had a network issue, and it was a critical point that we need to have discussion on it, and it should be decided. So claimant counsel was very adamant of not adjourning or postponing that particular meeting. So what I then suggested to the respondent that, can you come on WhatsApp? Yeah. And he said, yeah, I can do WhatsApp. So then I conducted the whole meeting on a WhatsApp video chat, on a WhatsApp video. So this is to ensure that, the meeting goes on, the critical issue, because time is also a factor to be looked into in arbitration. And in Indian perspective, let me just inform you, if you don't aware, we have the law which says that the arbitration, especially domestic arbitration, has to be completed in 12 months' time. It's a statutory mandate. So time is definitely a constraint. And definitely it's a very welcome step, no doubt about it. Therefore, this was crucial that this meeting should not be postponed. So I went into this, alternative mode of bringing everybody on the WhatsApp video, so that the meeting can goes on and the procedure is not unnecessarily postponed. So likewise, you see, these are the things. And of course, the counsel for the claimant also learned about this, that this can be also an option. So these are the things, which definitely are workable. This is for us to, showcase to the younger generation, to the practitioners who may not be aware about it. We have to be ourselves innovative, thinking forward. We need to come out of the shell of the traditional practice and keep ourselves in pace with time. Thank you.
Thank you very much, Samir. I mean, this just reminds me of the teaching work I do. So in the past year, I have taught dispute resolution, and in particular arbitration and advocacy, with a special focus on online advocacy to students from the Peking University Law School, to students from Renmin University Law School, and students from the East China University of Political Science and Law. And I think this is perhaps a useful illustration of the extent to which there is already, again, but albeit in a China-related context, the efforts to educate, equip the next generation of dispute resolution practitioners in dealing not just with the challenges of dispute resolution in general, but the challenges of dispute resolution as it will be in the future. And perhaps this is very useful point at which we can pivot to some of the questions we received in the chat room. And we've got about sort of 7 minutes left to go, unfortunately, before our session comes to an end. So what I'd like to do is to read out 1 or 2 questions that we have received in the chat room and see if we can get our panelists to weigh in. The first question that I'd like to pose, and this one's for you, Carrie. There's a question from Charles Ho. What essential skills do young practitioners need to possess to excel in the sphere of online dispute resolution? And I'd like to draw on, obviously, not just your experience as an arbitration practitioner and also from an institutional perspective, but of course, one of the things that we have not had time to go through, because you have got this sort of illustrious and distinguished CV. You are also professor of business law at California State Polytechnic University in Pomona. And no doubt you will have had this question posed to you on a number of occasions by your students. So I wonder whether you can enlighten us with your views on what essential skills young practitioners need to possess to excel in the sphere of ODR?
Thanks very much, Yunbei, and also Charles. I think Adolf and Samir have also alluded to their own experiences, kind of training next generations of dispute resolution practitioners. Personally, I'm not sure if everyone else agrees with me. I don't think there's like particular kind of set of skill sets that are unique to ODR practitioners that are not universally acceptable to other kind of legal practitioners that are in other types of legal practice, like corporate M&A, other types. I think a lot of the skills are basically like universal, and they are definitely interchangeable when you are switching from one direction to another direction. So some of the skills that all legal practitioners might possess, such as attention to detail, diligence, and quick learning abilities, are basically also applicable to next generations of older practitioners. I think you do need some wide exposures to different types of dispute resolution practices, because ODR itself is a hybrid of variety of different types of practices. So it has some trait of earlier mediation, also arbitration. So wide exposure to different types of dispute resolution definitely is going to be helpful. And also definitely to keep an open heart. So basically there are a lot of technology and other kind of issues that are very novel and sometimes maybe even difficult for people in the legal profession to learn, but for ODR dispute resolution practitioners that are kind of standing in the intersection of law and technology, I definitely encourage all of you to be willing to explore some different fields, especially those fields require a little bit experience in technology, to keep an open heart and definitely be willing to learn new things. I think those are something that I would recommend future ODR practitioners to have. I see Samir has a hand up already.
Kerry, I agree what you said. I just want to add one small thing, which, as you correctly mentioned, that there is practically no difference in the general practice and doing it in ODR. But one thing which I would like to point out is what is required is an overall confidence in yourself, that you as a practitioner should be equally confident and comfortable with technology. And that is, I think, is what needs to be learned by the younger generation when you are, because many times I have seen is that, a person may be well confident and well versed, otherwise there is no issue of knowledge or exposure. But when it comes to technology, even many senior practitioners like us would fumble. They won't be that comfortable. So I think what is required to be imbibed in the mindset is to be comfortable with technology.
Terrific. Thank you so much, Samir and Kerry, for your contributions. Last question. I'm afraid we just have time for one final question. This one is directed to Adolf from Vishal Agarwal. What happens in a case where the Lex Arbitri is silent with respect to any such provision on remote hearing, and it could get further complex if institutions provide for ODR but Lex Arbitri stays silent?
As a matter of fact, in this Austrian case law, in this case that I talked about today, there was nothing. There was nothing in the Lex Arbitri about that. So that's why actually the Supreme Court's decision was so crucial, was so important. And in international arbitration, we have a legal hierarchy of the sources, of the procedural provisions that are applicable in an arbitration. And on top of that hierarchy is always the mandatory Lex Arbitri. If we don't find nothing, the mandatory Lex Arbitri, we have to go down to the parties' agreement. If if the parties cannot come to an agreement on a certain issue, then we have to go down to the institutional arbitration rules. If we don't find nothing in the institutional arbitration rules, then we have a gap filler. That's actually, we return to the lex arbitri that is non-mandatory. Yeah, the non-mandatory lex arbitri. So if we have nothing there, we have no parties agreement, we have nothing, then we actually go to the arbitral tribunal. Then we have to check out what procedural orders are there, in particular, the procedural order number 1. Yeah? And of course, we also have to consider, this is basically the last legal source, soft law instruments that may be also may be applied by the arbitral tribunal as a guidance. We have that very often in terms of evidence. I mean, I don't have to talk about the IBA rules on the taking of evidence. Yeah. So we have to always stick to this legal hierarchy of procedural sources, of procedural law sources in international arbitration. I hope that answers the question.
Absolutely. Thank you so much, Adolf. And well, ladies and gentlemen, I'm afraid our time on this panel discussion, scintillating as it has been, unfortunately has come to an end. I did see at least one raised hand in the audience. Apologies that we are unable to get to you, but of course, if you have any further questions which you'd like to direct to any members of the panel, please feel free to get in touch with the AIADR, who will put your questions across to us. So thank you so much for your attention. Thank you for following our discussion. And thank you to the distinguished panelists whom I've had the delight and honor of moderating this morning, this afternoon. And I'd like to hand the event back to the AIADR now. Thank you so much.
Mr. Jinfei, Mr. Samir, Dr. Adolf, and Professor Carey, thank you all very much for the insightful discussion that we had earlier. I will now be passing the floor on to the Vice Chairperson of the YMG, Mr. Vishal Agarwal. A little background about Mr. Vishal. Mr. Vishal is a dual qualified lawyer, qualified in both England and India, who primarily focuses on commercial as well as investment arbitration, as well as arbitration-related litigation. He has worked on diverse investment arbitration cases with law firms in London. He is the senior editor of an arbitration book published by LexisNexis. He has also worked as a tribunal secretary with the Dubai-based arbitrator in the MENA region and has attended tribunal secretary training program. He holds an LLM degree from the London School of Economics, where he specialized in commercial as well as investment arbitration. He is an associate of the Chartered Institute of Arbitration and associate of the Asian Institute of Alternate Dispute Resolution. He is the founding chair of India's Very Young Arbitration Practitioners and has also been selected as the Young ICCA mentee for the year 2022 and 2023. Currently, Vishal is working in the area of construction arbitration in India. Vishal, the floor is all yours.
Thank you, Marlene. I would like to start by thanking AIADR Secretariat. I want to end this seminar by quoting few lines. John Porter once said, "People underestimate the capacity for change." It must be true since it has become appallingly obvious that our technology has exceeded our humanity. This is clearly reflective in the technology's impact on the dispute resolution services throughout the world, which was once thought to be a slave to pen and paper. Going forward, we can expect an exponential footprint of technology in dispute resolution services. On this note, I would like to thank our esteemed speakers for enriching this inaugural webinar, with a special thanks to our moderator, John Fay QC, for steering the discussion seamlessly. I would also like to again extend my sincere gratitude to Asian Institute of Alternative Dispute Resolution, its president, Dato Sundar Raju, and the entire team of Secretariat who provided immense assistance in organizing this inaugural webinar. I want to thank our chairperson, Charles Mark, and the entire working committee of Young Members Group for their efforts in planning and executing this webinar in a very short frame of time. Lastly, but not the least, I want to thank all the participants joining us for this webinar from different time zones and their different countries. I hope this webinar was enriching for each and every one of you. It gives me immense pleasure to share with you that we will soon be releasing out forms for joining the membership of the Young Members Group. We also have events lined up which are brimming with the knowledge of alternative dispute resolution, such as today. One such event is the AI-ADR practical workshop that is on interpreting the dispute resolution clauses, which is happening on 15th of July, 2022. I would want each and every one of you to follow the LinkedIn page of AI-ADR for all such future events and the membership updates. Now, I would request you to stay tuned and join us for the annual general meeting of AI-ADR, which will be starting in the very next few minutes. Again, I want to thank every one of you and wish you a very great day. Thank you. Over to you, Secretariat.
Thank you, everyone. See you shortly.